So
Anyway.
let's begin anew. I'm going to call the case. The case is Basic Services versus Government of the Virgin Islands. Each side has 15 minutes, and each side has 2 minutes of uninterrupted time to argue at the beginning of their argument. I would ask Attorney King whether he wants to reserve any time for his rebuttal.
Yes, I would, Your Honor. I would reserve 3 minutes for rebuttal.
Okay, thank you very much. And so after much work to try to get us all connected this morning, we can begin.
Good morning, Justices. I'm Robert King, and I'm here on behalf of Basic Services. This case is one that was previously before this honorable court. One of the issues that this honorable court decided was that the summary judgment which was granted was properly granted. And it also held that the issue of good faith and fair dealing was always properly before the Superior Court, though the Superior Court held to the contrary. This case involves basically the supply of technological services to the Department of Education through a program with the federal government, whereby the Department of Education was to pay 10% of the amount of the contract, and the federal government, the federal Department of Education would pay the other 90%. This case was initially brought in 2012 in order to avoid the lapse of the case because of the statute of limitations. Basic Services never really wanted to file the case. The only thing it really wanted to do was get paid for the services that were rendered. Now, when this case, when Basic Service filed this case, it involved 3 invoices to the federal government. And those invoices were for work that was already performed, because under the terms of the contract between the government and the U.S. Department of Education, the person was the supplier of technological services, was required to do all of the work for a period of 1 year. And following that, there was supposed to be an invoice sent to the government, and the government would both approve the invoice as to form and state that the service provider had done the work and the work was satisfactorily performed. There were 3 invoices in question. And when those invoices were submitted during the discovery process, the only thing we're really able to find out was that though the vendor had submitted the invoices to the government on a timely basis, the government failed to certify those invoices to the Department of Education, and with that certification to state that the services were provided, and the services were provided in a workmanlike manner. There was nothing else that we could find out. When Basic Services attempted to question about why it hadn't received these invoices, payment for these invoices, it initially contacted the Virgin Islands Department of Education, and pursuant to its contract with them, asked for the department to aid it in getting payment as the contract required. The government did make efforts in order to get payment from the Department of Education. I and Basic Services contacted the U.S. Department of Education in an attempt to find out why the payments were not made. The only thing that Basic Services was able to...
How did you, how did Basic Services contact the Department of, I take it you contacted the School and Libraries Division?
School and Libraries Division, Your Honor. And that was done both in writing and through telephone conversations with the persons who were there in Washington. And what was done is that they stated that, well, they were going to investigate.
The Superior Court found that there was a lack of due diligence.
That's absolutely not true.
I'm about to ask some questions about due diligence. You do agree that due diligence is a requirement under 60B2. You must not only have newly discovered evidence, but you must also show that you had due diligence, that you exercised due diligence.
I believe that's a requirement under B2, and I think it's also a requirement under B6. I think it's universally required that you have due diligence. And I believe that due diligence was shown here. It was shown here in that Basic Services did everything within its power to find out from the Schools and Library Division why it wasn't paid. The only thing that it was able to obtain was it is under investigation.
And Attorney King, when you found that out, what did you do to determine the scope and the substance of that investigation?
We asked questions. If we assumed, and maybe we're wrong in that assumption, that they were investigating why the payments weren't made, because that's what we were told. They were investigating why the payments weren't made. And periodically we would go back, and the Department of Education would go back in order to determine why the payments weren't made. And no matter what we asked, the Schools and Library Division would say they're not done with their investigation yet. Now, what we ended up finding was, like I said earlier, was that there was the only problem we found in discovery was the lateness of the submittal of the documents from the Department of Education to the federal government.
Why do you believe, or why are you arguing that the Superior Court was wrong when it determined and found that Basic failed to exercise due diligence? The Superior Court indicated that Basic did not depose any individuals. Basic did not conduct written interrogatories. Basic, what did you show this? What did Basic show the Superior Court to prove diligence on its part?
Your Honor, we've been down this road. This is not a new rodeo. There is nothing that Basic Service could have done to force the federal government to come to a conclusion as to, and give us a conclusion as to why it wasn't acting. The only thing that, whether we took a deposition or didn't take a deposition, whether we sent interrogatories, and they're not a party, so we couldn't send them interrogatories. So
let's see if I can understand this. Did not Basic at least get a response that there was an internal investigation being conducted by USAC?
That is correct. We did get a response, and we got a response that in every single time that we inquired, that is exactly the response that we gotten, and they would not disclose the nature of the investigation or the scope of the investigation. They just said that it was being investigated, and as soon as the investigation was done, we will have their findings. And
the Basic and the Superior Court and some of the cases have indicated that once, even if it's unlikely or impossible that the federal government will provide any information before an internal investigation is concluded, that nevertheless, there must be some effort made by the person trying to obtain the information. And so I think that is where the Superior Court, that is what the Superior Court was looking at, that Basic was inquiring, I take it informally, but there is no record for the Superior Court to point to say, well, Basic exercise due diligence. And that's what I'm trying to get here. That's what I'm asking you.
There was no question as to that. Here's why I'm saying. The court made a finding that the government did everything it could do to aid Basic in receiving payment. that the government made inquiries and did the same thing that BASIC did in order to try to find out what the investigation was and trying to find out why BASIC wasn't paid. The court found that because the government made efforts, and the same efforts that BASIC made, that the government had not breached its contract with BASIC to require BASIC to do more than the government was required to do, especially when the basic services liaison, the contact with the federal government, was not directly to BASIC. Although BASIC tried to talk to the federal government and find out, it was to act through the Department of Education, because the Department of Education's duty under the terms of the contract was that in the event there was a problem, the Department of Education was the entity that had the obligation to speak with the U.S. Libraries Division in order to get everything cleared up.
But Attorney King, these are apples and oranges. The government did what it was required to do pursuant to the contract by making inquiries and attempting to assist BASIC to get paid. But you're in a whole different setting. BASIC is in a whole different setting. BASIC has determined that it needed to initiate litigation it's been explained that statute of limitations may be a concern, so the litigation was commenced. Apparently, these informal discussions during the course of the litigation came up against not necessarily a stone wall, or the record's unclear as to whether it was a stone wall or not, but certainly there was no information gotten from those inquiries. And your briefing advises that BASIC simply assumed that it must be these late invoices. Of course, we know now that it wasn't the late invoices. Why didn't BASIC take additional steps, subpoena the USAC and or others, depose USAC and or others, or file a motion under Rule 56E? Judge, we can't respond to summary judgment at this point because we need additional discovery to find out what's going to happen with this investigation. None of that was done.
I agree with Your Honor that the ideal situation would have been file a Rule 56E motion. But we believed, even though that was wrongfully believed, that there was nothing else the government did wrong. That the only thing the government did wrong was to make these untimely payments, or else we wouldn't have cross-moved. There would have been no purpose in cross-moving. But just let's assume that we found out, for the sake of argument, let's assume we found out that early on, let's assume we found out that there was a conflict of interest and the government disclosed it. But even though we would have had that knowledge, we still couldn't force a decision out of the department in order to write its findings down and to give us those findings. This judge, no matter what, even if we made the assumption that the contract wasn't paid because there was a conflict of interest, the judge would have found that in absence of a ruling from the agency, then it was mere speculation on our part and a wrong decision on our part.
All right, I have a question. I have a question, Attorney King. It seems to me that what all that you have told us about what the government did according to addendum 2 to the contract, that section that talk about the government was agreed to assist the contractor in securing payment from SLD. What else could the government have done under the contract? So the government did make a bona fide effort by making calls, by contacting the SLD to try to expedite your payment. It had absolutely nothing to do, and the final decision of the SLD had absolutely nothing to do with the late submission of any information by the government. What I understand that it came up and they said there was a conflict in that because Mr. Joseph Philpott was on the committee that determined who will get the contract. And he had a gross conflict of interest in that he's a full-time employee for the Department of Education and he's a part-time employee for Basic. And they said with that conflict, we will not pay any more money. It had absolutely nothing to do with whether the government had submitted the payment late, extraordinarily late, or otherwise. In reading this record, I get a distinct impression that the only reason why that Basic didn't get its money over $1 million plus is because of the conflict of an individual on the committee, what I call the bidding committee. Now, my question is...
Okay, just a minute. We're 3 minutes over time, Attorney King.
All right,
So
okay.
you can save the conflict issue for the rebuttal, all right?
I will, Your Honors.
Okay, thank you. Attorney Francisco?
Good morning, Your Honors. Assistant Attorney General Michael Francisco representing the government of the Virgin Islands. Your Honors, I think the court is on the right track as far as the due diligence inquiry. I would first like to say, though, the government's position is that this evidence, these letters, do not constitute newly discovered evidence because they themselves were not in existence at the time the summary judgment motion was granted. Now, if the court were to assume that the facts underlying those letters do constitute newly discovered evidence, as the court has pointed out, appellant has failed on numerous levels to discover those facts. At the time, they had ample opportunity, not only the discovery tools that Justice Cabret mentioned, the Rule 56E motion that Justice Brady mentioned. The fundamental failure was to bring this information, the fact of an investigation itself, to the Superior Court. If the justices look at the Superior Court's order, which is well reasoned, it harps, at least in part, on the fact that none of this was brought to their attention in the first instance. They could have acted to grant a stay. There was a 3-month period in between the October 2017 decision and the late December letters, actually a 2-month gap. So really, the failure to bring the information to the court in the first instance, was fundamental. Further, they did not ask in interrogatories who was on the selection committee. That would have been an obvious question to ask to me.
Attorney Francisco, when you look at the history of this case, what was the date of this contract?
Your Honor, the contracts cover the years 2007, 8, and 9, but I believe the initial contract was signed in 2004.
And the case was started in 2012. Is that correct?
That is correct.
So the procurement process had long ended. Was it in the government's mind? Was it on the Basic's mind? I mean, there had been payments made under the contract. So I can see your argument about, why didn't they ask about the bidding committee? But why would they? I'm asking you, why would they ask about the bidding committee when there was no clue that this was a procurement issue?
Well, Your Honor, they brought the case, Basic Services brought this case based on an assumption. Now, it's okay to plead allegations in your complaint, but at some point you need to prove those allegations. And throughout the discovery process, there's several different avenues. I mean, the fact is, no one knew why the USAC had not yet paid these invoices, and it's not on the defendant or the appellees. It's not their duty to prosecute the case for the plaintiff appellant. They had these tools available. They could have deposed either the DOJ, someone from the DOE, the USAC.
Except, Attorney Francisco, that I think you will agree with me, that the government in this case contracted to assist basic services to obtain the money. So I think we have to look at the facts a little differently here. This was a contractual duty, and along with that contractual duty comes the duty of good faith. And here we have a situation where the government placed a part-time employee of BASIC on its bid evaluation committee. Who had this information? I mean, although it was long back, but within whose bailiwick? Who had this information within its power? I mean, who would know about this better than the government? And who would know better about bidding procedures, about conflicts of a situation such as this than the government of the Virgin Islands? I mean, we have to look at all the facts.
Your Honor, there's nothing on the record to suggest the government was ever aware that the DOE employee also had worked with or for basic services. Nowhere on the record is it.
This is the second time that you have indicated that.
Yeah, I
have
a couple of questions. Am I correct? The Department of Education is the largest executive branch department in terms of employees. Got thousands of employees, including, and has the largest part of the budget. Do you know that to be true, Mr. Francisco?
Your Honor, that is not on the record. I'm unaware of that.
All right. Okay. This whole thing here pivot on one thing, one solitary thing. It has nothing to do because the government did assist in the attempting to secure payments, but now BASIC is trying to turn around and said because of quantum merit, the government is liable for the 90% that SLD should have paid to BASIC. Only 10% of the contract was supposed to be paid by the government. So my question is, do you know this Joseph Filbert? What was his job at Department of Education?
Your Honor, before I answer that question, I would like to point out that this court's prior ruling in Basic Service v. Government of the Virgin Islands from 2019 established that amending the complaint would have been futile.
No.
To add unjust enrichment or quantum merit, because neither of those equitable remedies.
That's not getting to my question. My question is, when you have a bid, am I correct? It's open to the public. Do you know that? Whether or not it's open to the public?
Your Honor, I believe they are, but those facts are not on the record.
All right. Okay. Is there something when the committee make a bid or award a bid, the committee members, do they put their name on any document that the public can see who all was on that committee?
Your Honor, again, that is not on the record.
Well, but here is the rub now, because you see, what BASIC keep on saying is that the government knew that there was a conflict. And the fact remains is that did BASIC know that this gentleman, Joseph Filbert, was a part-time employee for BASIC for at least 2 years and worked for the Department of Education? Did BASIC had any knowledge at all that he was on that committee and stayed silent or said nothing and then get the contract awarded to them? The fact remains is that blaming the government is not the key. The government is not to blame here, because the government could have only have divulged or disclosed that Mr. Joseph Philpott had a conflict if it knew that Joseph Philpott was a part-time employee of BASIC. But so would Mr. Ray, who is the head of BASIC. He had to know that his part-time employee is a Department of Education employee for 2 years, and he should have inquired, since he have this $1 million contract that's coming with Department of Education. And what I understand that BASIC is trying to do is impute knowledge to the government that the government know that Mr. Joseph Filbert, who was on the committee that awarded this bid to Basic, that the government knew he was a part-time employee of Basic. But the fact remains is that the Basic knew that also. At least Mr. Filbert, he knew that. So what was Mr. Filbert's job? Because I know he was on the committee, but what does he do over Department of Education? Nobody knows.
Your Honor, upon information and belief, he at the time was a network technician who assisted the Department of Education with the with their IT. I can't really speak beyond that.
All right, but do you know, in other words, is there anything in the record at all that we could take judicial notice of, that there's a policy over the Department of Education that these employees, thousands of employees, when they have part-time employment, they have to let the Department of Education know that they got part-time employment and with whom? Because what now Basic is attempting to do is saying, all right, the government should be liable for the 90% of the part of the contract, when under the contract it's only liable for 10%. That's number one. And number two, they come up with this idea of under quantum merit, the theory of quantum merit, that the government is liable for $1 million+ only because SLD told them we will not pay Basic. And the only solitary reason why they are not paying Basic has nothing to do at all with late payments, have nothing to do at all with the submission of late information. It simply has to do with a conflict of interest on the part of Mr. Joseph Filbert, who was a full-time employee at the Department of Education and a part-time employee of Basic. And they say that because of that conflict, we cannot condone that, and therefore we will not pay the amount of money, their 90% under the contract. So Mr. Joseph Filbert looms large here, and I want to know what information that Basic had, whether they knew that he was on the committee, the bidding committee, and stay silent. Did they see his name afterward on any document and stay silent without divulging or disclosing that he had a conflict with them? The conflict of interest is what this is all about. That's why SLD refuses to pay the money. And to now try to divert and say, well, if SLD doesn't pay, then the government should be responsible for the quantum merit. That's just mind-boggling. And I am shocked and surprised that nobody have asked what knowledge did Basic had that Mr. Filbert had a conflict of interest by being an employee, part-time employee of Basic and a full-time employee of the Department of Education, and sitting on that committee that awarded the bid to Basic. And then the whole thing is that, is there a procedure at the time that the bid was opened? Was it in a public place, as some bids are done through property and procurement, that everybody is present, every bidder is there present to see who is going to win this bid, and they have to see who is on the committee? That looms large, and I haven't heard anything about that at all. That is my problem with this case.
Do you have a question about that, attorneys? Do you have a question for Attorney Francisco about that conflict, Justice Swan?
Yes, he hasn't been able to answer because he hasn't been able to tell me anything at all about the role of Mr. Joseph Filbert and how did he get on the committee, or how was the bid open? Was at a public place, a public opening of the bid, so that everybody would know who it is that was on the committee? Because Basic is saying that in essence, I didn't know that he had a conflict, but the conflict would have been glaring to anybody who had attended the session for the opening of the successful bidder. If it was public, then Basic would have real constructive knowledge that his part-time employee was a part of the bidding process, or the committee that decided who gets the bid.
I don't see Mr. Francisco on the screen.
Attorney Francisco?
Yes, Your Honor, I'm on my cell phone.
Okay, thank you. Did you hear the question?
I'm sorry, Your Honor. Our internet cut out in the middle. I certainly have the gist of Justice Swan's question. I didn't know if at this point I was still.
You have one minute. You have 1 minute left.
Your Honors, I would just like to say I appreciate Justice Swan's inquiry into the facts, and I understand that I do agree with him that BASIC should have known that its employee had worked for the Department of Education. Although the facts underlying the what happened are opaque at the moment, the fact of the matter is appellees are seeking to have, or excuse me, appellant is seeking to have this court save it from improvident decisions it made. As far as how to prosecute its case, the evidence that was presented did not save them under 60B2. Neither would it be applicable under 60B6 for the reasons stated in our brief, and those in opposition to appellant's briefs below. And I think the court.
Mr. Francisco, you said that the letters are not newly discovered evidence, but what about Mr. King's argument that the information contained in the letters did exist before the decision was made, and therefore that information without the letters themselves can be considered newly discovered evidence?
Your Honor, I think that the
Attorney Francisco, your time is up, but I'm going to give you a minute to answer that question.
Thank you, Your Honor. Justice Brady, we would say that the letters themselves, as the Superior Court found, were the payment denial nor the reasoning for the denial, as represented in the letter, were in existence at the time. So perhaps the facts underlying them were. But as the Superior Court relied on a similar fact pattern in Banks v. Thomas, which I believe we included in our brief, in that instance there was an expert report by a psychiatrist. The underlying medications were those facts were in existence, but his report was not, and the court in that case deemed the report to be not in existence at the time of trial and therefore not newly discovered.
All right. Thank you very much, Attorney Francisco.
Thank you, Your Honors, and I do apologize for the internet going out.
That seems to be happening this morning. All right, Attorney King.
Your Honor, I think there's something that's very important that's being missed here, and I think that Judge Swan has hit a point that I really want to make. We're not asking that the court enforce the contract or cause us to be paid. Judge Swan's questions are the very questions that would be answered if the 60B motion were granted and we got a chance to litigate this matter to find out the precise answers that the court is asking. I know that Mr. Filbert was an employee of BASIC and that the Department of Education hired him out from working for BASIC. But that's not a fact. Actually, that's on the record of this case. My knowledge has nothing to do with this court's knowledge. What we're asking is that—
Attorney King, do you disagree with the decision that USAC made? And it's not really a part of your case, but did they make the wrong decision?
I can't say it was the wrong decision. It probably was the right decision.
So you don't maintain
it was their decision to make. They could make. There's nothing that BASIC could do to challenge that decision. It was over. If they said they were not going to pay, they couldn't. They didn't have to pay. BASIC has no way to—
Can you make a claim now against USAC?
No.
And if it's still within the, if it's a contract claim, you're within the statute of limitations period from the date of the denial.
They're not a party to the contract. But here, I'm more concentrated on 60B6, and 60B6 is a well of equitable considerations. And what it does is it says, look, in the interest of justice, this motion should have been granted in order for BASIC to go ahead and litigate its claims. Now we knew.
Aren't 60B2 claims and 60B6 claims mutually exclusive? And if you bring a 60B2 claim, then you're precluded from bringing a 60B6 claim.
No, sir, they're not exclusive. In fact, we argued 60B2 and 60B6. We didn't argue them in any particular order. Under 60B6, the factors that the court considers is this general desirability that the judgment should be final and not disturbed. But the court must weigh whether or not justice requires a decision to be opened up. And that weighing is what this court failed to do. And what I believe is that the equitable consideration, who's losing here? BASIC is losing. It's losing all of its services, losing $1 million or 500,000, whatever the amount was that for the labor that it gave to the government. The government is the one that's being unjustly enriched, and they're the ones supposedly causing the conflict. Whether they caused it or they didn't cause it, whether the BASIC's going to recover or not, that should be a decision that's made on trial. Now that we actually know what happened, and what I'm saying to the court is, let us litigate this. Let the court determine who's right, who's wrong. Don't just throw us out. That's what I'm asking.
Your time is up, Attorney King. Thank you very much. This matter is under advisement.